the budget bill, as it was reported, extended this moratorium to January the 31st. And then there was the new CDC order that extended it through June the 30th. The important thing to know in the District of Columbia is that the CDC eviction order applies unless there is a more stringent local restriction. In DC, we have a more stringent local restriction, right? There are no evictions in DC. There are no filings in DC right now. So, for all intents and purposes, right now in the District of Columbia and moving forward into July, the CDC eviction moratorium doesn't apply. Now, I say moving into July because it's possible. I don't think it's likely, given the way virus case numbers are moving, given the way vaccinations are moving, that the CDC extends this order again. But if it is extended again, just keep in mind that in DC, we have a more stringent restriction in place, and so it doesn't apply. That said, it's not bad to know about it. Your tenants may give you a CDC declaration form. If they do, obviously put that in their tenant file. Make sure that anyone who's interacting with them or is aware of that, and be mindful of that as in the next several months we move out of, or hopefully move out of, the public health emergency and into a posture when landlords are again able to file cases in the District of Columbia. So to support the CDC eviction moratorium, the Consumer Financial Protection Bureau issued an interim final rule which required debt collectors to provide written notice to tenants of their rights under the eviction moratorium and under local law. The notice has to be clear and conspicuous. It has to be dated the same date as the eviction notice or the filing date. This was effective May 3rd. If you're thinking to yourself, oh my gosh, what is he talking about? I don't know anything about this. The reason that you don't know anything about it is because in the District of Columbia, pursuant to an October 2020 law, we can't give notices to our tenants. We can't give eviction notices. We can't give 30-day notices to correct or vacate. So we're not contacting our tenants anyway right now with regard to breaches of lease or failure to pay rent. So we're not obligated. Well, if we were contacting them, we'd be obligated. But since we're not obligated to really be mindful of this rule. It is important to be aware of because, as I said a few moments ago, as we hopefully move out of this public health emergency in the next several months, and we begin again to be able to issue notices and file cases, it'll be important for us to monitor what happens with this CFPB rule and whether or not it's rescinded, as the CDC eviction moratorium is hopefully also rescinded, or whether or not this rule remains in place. I think there's probably a 50-50 chance that this rule remains in place, in part because, as you guys are no doubt aware, there has been so much federal money allocated for rent relief. And one of the things that I think the CFPB may want landlords to do when they are moving to file cases against their tenants for failure to pay rent is make them aware of the federal and or local rent relief programs that may be available to those tenants. So it wouldn't surprise me if this rule sticks around, perhaps in a slightly modified format, and is something that we need to be aware of as we begin to be able to give notices to our tenants. Speaking of rental assistance, $25 billion has been allocated nationally. This is the first time this has ever happened in the history of America. So this is a big deal for the federal government to step in and provide this kind of funding to essentially underwrite a rental housing crisis. In the district, $350 million has been allocated. The funds have been set aside to help people who have fallen behind on their rent and are facing eviction. I understand, although I don't know this for a fact, I've heard many people say it, including several DC council members at a legislative session, that the district has an obligation to get a substantial amount of money, which is, I believe, is $160 million out the door before September the 1st. Between you and me and everyone else who may watch this later, I don't think that that's going to happen. I don't think, though, that the district is going to be alone in terms of the jurisdictions who've been awarded funds and are not able to allocate them as quickly as the federal government requires. So it wouldn't surprise me if there is some sort of extension granted here. That said, you should all become, or probably already are, frankly, familiar with the Stay DC program. It has its problems, for sure, and I'm sure some of you have experienced those problems, but it is the program that the district is using right now, and I anticipate it will be the program that the district continues to use to get these dollars into the hands of landlords whose tenants have fallen behind. So my recommendation is to, apply early, apply often, to keep in touch with the folks from Stay DC who may contact you, and to pay attention to the news. I know that there is a working group that has been formed by the council and the Apartment and Office Building Association. They've got a couple of larger landlords, they've got a couple of tenant advocates, and they are working together to try to rectify some of the problems that both landlords and tenants are experiencing with the Stay DC program. I will say that this program is one area where I think that landlords and tenants are united, in that everyone's frustrated, and I think that the tenants and the landlords both have the same interest in getting the funding that's available out the door and into the proper hands. If you have horror stories or positive stories, then please feel free to share them. I'm always interested in hearing more about how this program is working, especially for small landlords, because I do think that small landlords are the ones who are being asked, have been asked, are being asked, will be asked to bear an unfair share of the burden associated with this pandemic. So I'm interested in particular about how you guys are faring when it comes to obtaining rent relief for your tenants. In the district, the public health emergency, by virtue of a combination of a mayoral order and some council legislation, has been extended to July the 25th, 2021. Of note, the legislation which authorized the extension notes that subsequent extensions of the public health emergency will be in 2-week increments. I think this is a very positive development because it indicates to me that the council believes that larger extensions of the public health emergency will not be necessary. My hope is that the public health emergency is allowed to expire on July the 25th, and thus the clock begins running on all of the many deadlines and filing moratorium that exist in the District of Columbia. In DC right now, almost all businesses are permitted to resume full operation with no capacity limits. Businesses can still impose, if they would like, mask and capacity limits. There is no limit on large gatherings in DC, provided there's compliance with DC health guidance. Essentially what that means is that those who are vaccinated don't have to wear masks, and those who are not vaccinated are expected to continue to wear masks. I have to tell you guys, I was in Baltimore today. That city is not open. There are mask requirements everywhere. Restaurants are closed. It is a very, very different place than the district. So while I know that there's a lot of frustration in DC right now, and I'm not suggesting it's unfounded, it is not great elsewhere either. Some of the restrictions that remain in place: you cannot increase rent during the public health emergency. You cannot increase it for an additional 30 days after that. However, the real number on that rent increase is probably 45 days, because in DC you have to give your tenants at least 15 days to contemplate a rent increase or a renewal offer before they need to give you a notice to vacate. So if you have a month-to-month tenant and you give them a rent increase, that rent increase really can't take effect for 45 days because they'd have to give you at least a 30-day notice if they wanted to give you a notice to vacate rather than accept the rent increase that you've provided. There's no debt collection during the public health emergency and for an additional 60 days. There's no filing of any suits for eviction for any reason. I'll get to the public safety exception in a minute. During the public health emergency and an additional 60 days. That law was passed in May of 2020, but was retroactive to March 11th of 2020, the beginning of the public health emergency. No issuance of 30-day notices for any reason. Public safety exception to be discussed momentarily during the public health emergency and for an additional 60 days. So one thing to keep in mind, if the public health emergency expires on July the 25th, there's still going to be a fairly lengthy 2-month run-up to when filings can occur, when notices can be issued, right? So I think rent increases can go out immediately, right, for an effective date that's consistent with District of Columbia law. But even after the emergency expires, there will be some time built in for a continued delay. You cannot charge late fees during any month that the public health emergency was in effect. So currently that's March 2020 through July of 2021. You have to affirmatively offer a repayment plan with a minimum payback period of 1 year to tenants who've been impacted by COVID-19 for rent and other charges that have become due during the public health emergency. Tenant deadlines, for example, those related to TOPA, are tolled, which means that they'll pick up again where they were when the public health emergency expires. Amenity fees must be refunded if you've closed an amenity during the public health emergency as a result of the mayor's orders or other safety concerns associated with COVID-19. There are increased cleaning requirements for common areas of multifamily properties, high-touch areas. The marshals will not conduct evictions during the public health emergency. However, I will note that they are gearing up to resume evictions when the public health emergency lifts. And I say that because our office has been contacted as recently as yesterday by the court about writs that we had filed in, you ready for this? February of 2020, to see whether or not those evictions remain necessary. In most cases, they do not, as you would probably expect. Okay, the public safety exception. So the public safety exception to the eviction moratorium was passed to much fanfare in early May. And it was widely reported, at least in the reporting that I read, that this was going to be a game changer and that, a number of evictions would be forthcoming. This exception is extremely narrow. This exception permits landlords to issue 30-day notices to tenants who are engaged in criminal behavior at the property and whose presence constitutes an ongoing threat to public safety. Think assault with a deadly weapon. Think possession of firearms. Think arrestable felony offenses if you want to understand what is really covered by this law. The other part of this law that's important to keep in mind is that you're giving a 30-day notice to cure or quit. So the tenant can stop the behavior and thus preclude you from being able to file a case. So, look, we've given a bunch of these notices. If you think you have a tenant who's a candidate for this notice, reach out and we can certainly evaluate the situation and let you know whether or not we think it's appropriate to give this notice. We haven't filed any cases yet. I do anticipate that when we file cases under this exception, they will be hotly contested. I also, between you, me, and everyone who may see this recording, don't think that these cases will get into court until October. I think that the court is so backed up that they don't know how to schedule these anyway. And I think it will be a very, very long time period before we get these cases into court. So since I last spoke to you guys, what else has happened? These laws, these next two laws, are not related directly to COVID-19, but they have been passed during the public health emergency, and they have fairly significant ramifications for landlords citywide. The Fairness in Renting Temporary Amendment Act, and let me say first that this slide is, an inch deep and a mile wide on this law. We could have an entire presentation about just this law. This was enacted without the mayor's signature. She did not sign this law. This requires landlords to issue a 30-day notice before filing any case, including cases for non-payment of rent. It requires landlords to issue a separate 30-day notice of intention to file a claim. That is a brand new obligation in the District of Columbia. It requires photographic evidence if your process server serves by posting. The photo has to have a timestamp on it. It prohibits landlords from filing if a tenant owes less than $600. It prohibits evictions if a landlord does not have a current business license. It permits the sealing of eviction records in certain circumstances and mandates them in others. We have already seen a significant number of cases get sealed automatically by the District of Columbia Superior Court. It changes the application process a little bit and prohibits landlords from utilizing the credit score number as a thumbs up or thumbs down decision on an application. This, I suspect, has fairly significant ramifications for small landlords who do not have the ability to hire, a large third-party provider that will come up with some fancy algorithm and create, a leasing score or a tenant risk score that takes into account all of the information in a credit report and spits out a different number. But important takeaway, the credit score. So if your process is, I deny everyone who's below 550, that can't be your process anymore. You've got to change your process and have a more nuanced way to evaluate applications, which I know is easier said than done, for sure. The Rental Housing Source of Income Amendment Act. So under this new law, source of income is defined to include Housing Choice Voucher Program participants and those who participate in any district law or program which authorizes the payment of rental housing assistance. So this casts a much wider net on source of income. It is a subtle but a significant change because, as many of you no doubt know, there are many, many agencies and organizations in the district that provide rental housing assistance. This new law also importantly requires in any written notice, statement, or advertising of a dwelling unit for rent, the housing provider must clearly state that the housing provider will not refuse to rent a rental unit to a person because the person will provide the rental payment in whole or in part through a voucher for rental housing assistance provided by the district or federal government. That's a big change. So if you are advertising on Craigslist, if you are advertising on apartments.com or other similar sites, please make sure that your ads contain this language or some approximation thereof. We accept vouchers and subsidies welcome, something that indicates your compliance with this new, broader law with regard to source of income. All right, So that's the DC law portion. And Carissa, as you know, I've got 6 full minutes left, unfortunately. So if you want to open it up for questions, I'm game. Or if you want me to keep going, I'm game. You let me know.
Thank you, Billy. So I do see one question in the chat box.
Okay.
It's regarding the business license. So can you speak to that? Does a unit need to be registered under a business license before a landlord can file eviction?
So the way that I read the law is, as I've written it here, you do not have to have a current business license to file the case, but you have to have one before the eviction occurs. In Maryland, you've got to have a business license to file. Look, I think it's a good practice to have the business license, frankly, before you do any of this stuff, because there are administrative remedies for tenants that they could exercise against you if you don't and you collect rent. But I don't read this law to say that you're prevented from filing, only that you're prevented from conducting the eviction. And I don't know how that will play out. I suspect that the marshals will require some sort of evidence of the business licensure before they conduct the eviction.
Okay. Second question is, if you have, and please put your questions in the chat box. If you have a rental unit within your home, should you acquire a business license?
So is it that you live in? If you live there and you also rent out a room or something like that, then you may be exempt from the requirement to obtain a business license. I'm not 100% sure, and I need to do a little bit of research on that, but I will tell you that in many cases, if someone is renting out a room in the home in which they live, a lot of laws, on the fair housing side anyway, don't apply.
Okay. All right, Billy, next question is, a landlord served notice to quit August 2019. The tenant agreed to vacate. Do they have to serve this tenant again?
Well, it depends upon how the tenant agreed to vacate. If the tenant provided you a written notice that the tenant would vacate and then didn't vacate pursuant to that notice, and that vacate date was prior to the beginning of the public health emergency, then the answer is probably no. That said, by the time you're able to get that case into court, it will have been a very, very long time. And so I would anticipate a judge or a pro bono attorney that your tenant may come into contact with giving you a little bit of a sidelong glance and saying, "You want us to enforce what now? A notice from how long ago?" So I would be prepared for that, and I would recommend, I think at this stage, that, and maybe you've already tried this, that you actively engage with that tenant to try to come to a resolution short of having to file in the court.
Okay, great. Thank you so much. Another question is regarding TOPA. They want to know if you can provide more information on the deadline for TOPA toll.
Yes, so TOPA is just not existing right now because of the public health emergency. So sales of tenant-occupied multifamily properties, and frankly, even single units, they're just held up unless you can come to some sort of an agreement with the tenant directly. So if you're trying to sell a tenant-occupied property, you really need to engage with the tenant and get them to, acknowledge receipt of a TOPA notice, not waive their TOPA rights, but assign their TOPA rights. And I would recommend working directly with a title attorney if you're going down that road, because ultimately, the title companies are the keepers of the keys of the kingdom when it comes to TOPA. And you've got to satisfy their insurance company's underwriters. So I would start there and say, what do I need to get from my tenant in order to sell this property? And be prepared to pay.
All right. And so, Billy, we have time for one last question. It looks like the landlord is asking, when is the moratorium ending for a landlord who wants to own or occupy their property?
So that notice, unfortunately, was not specifically carved out in the eviction notice moratorium law. So it's the same, right? That law treats all notices to vacate the same. And so not the 90-day notice for personal use and occupancy is just like a regular notice to vacate or notice to cure or quit. So it's public health emergency plus 60 days. So that would be the end of September, approximately September 25th or 26th. You'd be able to give that 90-day notice. And that brings you, I think, until about the end of the year when the tenant would have to be out.
Okay. All right. So there's a question in the chat box. Do you take cases? And I think I can answer that for you. Yes.
Yeah, I'll put my information up, and Carissa, I'll share this PowerPoint with you. Yeah, I'm sorry. This was sort of last minute, and I forgot about this other obligation that I had in a few minutes. So I wish I could be with you longer and discuss this. And so Chris, I'm happy to come back and talk in more detail at your next meeting or one of your subsequent meetings if that's something you guys would like me to do.
Absolutely. So let's maybe consider doing a part 2 next month, just depending on schedule and availability.
That sounds good. That sounds good. Well, thank you guys for the time. I'm sorry it was so short, and have a good rest of your meeting.
Thank you, Billy. Thank you so much. Okay,
Bye-bye.
so Billy is leaving, but I still want to make sure that I am getting all of your questions because I'm going to have Billy to come back and answer more questions because I know that a lot of us, we have a lot of questions pertaining to the eviction moratorium. What can we do for tenants who haven't paid rent, right? How to deal with, and I see some of your questions in the chat box, how to deal with emotional, well, more along the lines of tenants with emotional or mental behavior issues. And so we have had and maybe you missed a previous meeting, and I can share that information with you. But we had Ms. Brandy Gladden from the DC's Department of Behavioral Health. So she gave us some tips on how to deal with those type of tenants. So all of your questions, if you will, please go ahead, place your comments or your questions rather in the chat box. I will make sure that we answer all of them. So we will do a part 2. We will have Billy to come back next month and spend a little more time in depth going over the law, the changes, and he did provide his information. So if you are in need of an attorney, obviously they can help you, but I thought it would be helpful to have him to come on and answer these questions because it costs you nothing to show up to get this information. And so if you just give me like a list of all of your questions, when he comes back next month, we can have all of that covered. You won't have to pay a consultant fee. You won't have to pay that hourly fee or whatever they charge to consult with you because there's a fee if they take you on as a client. And so if that's helpful for you, please let me know what your questions are, what your concerns are. So all of your questions, please put it in the chat box. If you do want to unmute yourself and ask your question, you can, but I am definitely going to record everything that's in the chat box.
Hi, Carissa. This is Takala. May I ask a question?
Yes.
Well, so I have several questions. You know, I was one of the attendees asking several questions to the attorney. So basically, my story is that I started the eviction process before COVID started. So we went to the HUD, arbitration. The tenant agreed that they were going to vacate. They signed the paperwork and everything. But now that was back in November of 2019, right?
Mm-hmm.
So, January come, February come, 2020, COVID came, so I couldn't do anything. I couldn't evict her. But so she's holding over until now. She's not willing to. The other thing I'm having challenge with is now the utilities are in my name. And I've been asking her if she could at least take on the utilities in her name, and I'll get a reduced rental payment. There is government assistance for the utilities. She is refusing to do that. And then the HUD is saying, well, you have to enforce your lease. There's nothing we can help you with, to change the lease, to the lease terms. Is there any way for me to change the lease terms so she'll be responsible for utilities? I mean, there's money available, but she's not willing to go through that.
So when you say HUD, do you essentially mean the DC Housing Authority, or you have a direct contract with HUD? I just want to make sure that I'm clear.
The DC Housing, that's correct, DC Housing.
Okay, so the tenant must agree to the change of utilities. And usually when that happens, the housing authority will enter into a new contract, but the tenant must consent. If the tenant doesn't agree, then unfortunately you can't make the tenant put the utilities in their name.
In her name, right. Yeah, okay. Well, that's where I'm stuck, and I'm just, and there's no rent increase, so there's nothing we can do.
Not at this time, unfortunately.
Right, okay, thanks.
You're welcome. I wish I had better news for you. See, I do see a couple of comments in the chat box regarding the DC Stay program. It is not too late to apply for the DC Stay program. Please go online, apply. I do see a question regarding the tenant. Well, let me just explain that the DC Stay program that Billy was talking about, it's money available to assist tenants who are delinquent on their rent. They will pay the landlord directly. However, it is a two-part process. So the landlord can apply. Usually, let's say, for instance, I'm going to use Anna Sumter. Anna, she has tenants who are not current on their rent. They haven't paid. So Anna is a very thorough landlord in the DC metropolitan area. She's gone online. She's completed the application for all of her tenants. So she has, let's say Anna has a total of maybe 362 tenants. 49 are delinquent. So Anna has completed an application for all of her tenants. Now, Anna has done her part. The agency will contact the tenants to say, hey, Mr. or Miss Tenant, your landlord, Anna Sumter, has completed an application for assistance for you. So the tenant has to fill out their part. The government will not pay Anna if the tenant is not responding. So it's a two-part application. So what do you do? I see your question. So what do you do? How do you handle a tenant who refuses to cooperate, who refuses to complete the application? Just gently let the tenant know, listen, you're delinquent on the rent. The city does have money to pay on your behalf, but in order for them to pay it, you have to complete the application. Let them know that if they don't complete the application, when the courts are open, and here's what I tell my tenants, I'll tell them, listen, we're not out of the eviction moratorium yet, but the courts are starting to open and they are starting to allow landlords to file cases in court. If I file an eviction case against you, it's going to be really hard if you're trying to rent somewhere else. So save yourself the embarrassment, save yourself that money, and just go ahead, complete your part of the application and let the city pay it for you. That way you can save your money. And so it's always better if you, and I just have this philosophy that you can catch more bees with honey than you can with vinegar. But worst case scenario, if you try to be sweet, if you try to be nice, if you try to go above and beyond, and the tenant still does not cooperate or participate, unfortunately, there's nothing that you can do but take that tenant to court. When the courts are open, go through the process that we just heard tonight about how to file an eviction. You have to wait 60 days after the public health emergency is over. And you also must demonstrate that you invited the tenant to enter into a repayment agreement for minimally 12 months. Okay, so that's why I wanted us to have this type of meeting, this forum where an attorney comes in to share this information, because a lot of people don't really understand. They think that, oh, well, as soon as the eviction moratorium is up, I'm just going to file for eviction. It's not that simple and it's not that easy, unfortunately. So continue to drop your comments in the chat box. I'm going to go through them, what I can answer myself. And again, I am going to have Billy to come back next month. We'll have, let's spend maybe about an hour. That way he can answer all of these questions. I'm going to provide these questions to him in advance. That way he will know how to answer questions. So please keep asking your questions. And if you want to unmute yourself, go ahead. I'm going to just go through the chat box really quickly.
One more question, Carissa, here.
Okay.
would it be best to email you the series of questions we have for the attorney? Would that be better than the chat?
That would be great. My email address is carissa@dchpa.org. Many of you on this this call today, you should have received an email from me, but if you want to email me your questions, please feel free to do so, carissa@dchpa.org. And thank you for that question.
Thank you.
Carissa, I put my question in the chat box, but I wanted to know, I wanted to know if you recommend offering money to the tenant to move out.
Yes.
That's a great question, Barbara. Thank you so much for that. I would definitely suggest we call that a cash for keys deal. If you have a tenant and you think that they may need a little incentive to move, then definitely by all means. Yes, ma'am.
Hello?
Great answer. Great answer.
Hello.
Yes, Amanda.
Oh, hi. Thanks for answering that. That was a great question, by the way. I have a tenant that doesn't keep the property up. I know that the rules are you cannot call someone a hoarder or anything like that, but right now I have liquid combustibles. They keep gasoline in my basement, well, in their basement near the hot water heater. There's tires on the front porch and everything else. I've done all that I possibly can to let them know, please kind of clean up, but it hasn't worked. In May, last May, they actually had a fire at the house because of their fault. What can I do now just to let them know, like, please just keep the property up? I don't know what else to do because I'm just afraid that it's definitely it's a health concern right now, and I just don't know what to do.
So let me speak to Billy on that and
Okay.
how he can give me guidance or advice for you,
Thank you.
especially because they're keeping gasoline on the property.
Yeah.
And because there has been a fire previously, that's a
Yes.
concern. So I'll speak to Billy to see what he advises or recommends. So let me follow up with you on that, Amanda.
Okay.
Amanda, please email me.
Yes.
Please email me, that way I can follow up.
Great. Thank you so much, Chris.
You're welcome. It's my pleasure. So I see questions. Hey, Jackie, I see questions regarding the state program. So if you applied for the state program and you have not, okay, so Jackie, unmute yourself for me. Let me understand your question if you're still on. So did the tenant complete their portion as well?
Hi, yes, the tenant completed their portion and I completed mine. This was back in April, and I have not received any correspondence or anything from this program. I actually called in and I was told by the representative that they can't provide any information because they don't have access to the applications or anything like that.
Unfortunately, that's the response that we're all getting. I haven't heard back. I don't think anybody has just yet. And so I'm not sure if you heard the portion where Billy explained that the city has like did he say $160 million that they have to get out by September 1? And a lot of people don't think that it's going to happen. So, but we're not sure the status of applications, when they're going to get started. DC hasn't contacted anybody. And we're all in the same boat because a lot of landlords on this call, on this Zoom today have applied and have not heard anything back. So we don't know, unfortunately. So when I call, I get the same response.
Okay. Okay. So I just kind of have a question. The tenant that I'm actually speaking of has a mental illness, and he actually destroyed one of my properties. He caused bed bugs. There was a stabbing on the property. I think he tried to choke out his girlfriend and she stabbed him. So the property, I pretty much had to gut the whole property, remove the carpet and everything like that. And it's still not habitable, even it's been about 4 months, and I had to move him or relocate him to another property. I haven't received any money from him since December. He was under a program and he was kicked off of that program, I suppose. But what I'm wondering is, once everything is over, right, and I probably won't receive any money from the DC stay program or anything like that, can I just go down and file the eviction? I haven't given him anything for a payment plan. He's not going to pay. He has no job.
So, and those are great. Those are great questions. So have you sent notification to him that he's delinquent on the rent?
Well, yes, he knows because he has a caseworker, and I sent that information to the caseworker, you know, the lease and everything, showing that he hasn't paid rent, just stating that he owes since December. So he's aware, and his caseworker is aware as well, but yet they still have him in the house. And even when I relocated him to the other property, when he got there, we had to call the police on him a few times because of his mental issues and stuff like that. So it's crazy.
Okay, now let me ask I'm asking a series of questions. So have you sent the notice to this tenant every month, letting him know what his rent balance is?
No, I have not.
Okay. Have you sent notification letting him know that you are inviting him to enter into a repayment agreement?
No, I have not.
Okay, you want to do that because at the conclusion of this public health emergency, you will have to show the courts that you've extended all of this to him.
Okay.
So if you haven't done it, do it today, do it tomorrow. And every month that he's delinquent, although there is some sort of mental health issue, some behavior health issue, still document it, because it's not what we know, is what we can prove. And so whenever you get to the court level, you don't want the court or the judge to dismiss it because you haven't dotted all your I's and crossed all your T's. So although you think or you believe or strongly know that, you know, he has some mental health issues, he's probably not even going to understand it. You still have to show the courts that you've done your part.
Well, I know his caseworker that, you know, for the mental health, you know, he has somebody that's helping him. So there's proof that he has like a mental illness, because this individual is stating that, hey, I'm helping him. He wasn't receiving any help during the pandemic and stuff like that. And I'm like, oh, okay. So that's the only reason why I haven't really bothered him. I haven't said anything to him. I've pretty much just sent all the information to that caseworker, letting him know this tenant owes this amount in rent or whatever.
Okay, so, and I'm making this suggestion because if you treat it like a business, it'll pay you like a business. And so the case manager is for him. The case manager is not going to advocate for you in the court.
Okay.
So that's why you want to conduct your business, because it's your business, it's your rental property. That case manager may be available. The case manager may not be available in court. And so you don't want to rely on anybody else. You maintain control, which means you're showing the courts whether the case manager is there or not. Your Honor, I've sent the notifications. Here are reports. Here are emails that I sent to the case manager. Make sure you are printing those documents, or at least you have it available for print whenever you do get to court level.
Okay. Okay. The tenant doesn't have like an email or anything like that.
That's fine. The email that you've sent to the case manager, just print it out, showing that you've tried to work with support workers that are available in the community to help the tenant, and none of those efforts has changed the behavior or changed anything. So you just want to demonstrate everything that you've done to try to work with this tenant, but you definitely want to send that tenant a letter every month.
Okay. All right. Thank you so much.
You're welcome. All right, so I'm going through the chat box for more questions.
Carissa, I have a question. I mean, not a question, but a quick statement about the DC Stay program.
Okay.
My wife and I have one property, you know, a single family house. We were fortunate enough to respond to the emails for the stay program right away. We've got responses and we've gotten paid. As a matter of fact, we've gotten asked to submit again for a second round. I think the secret, the only thing that I will you know, contribute or advise is you got to stay up on those emails. If they contact you or you see anything from them, you have to respond immediately. And that's what we did. And we actually got a check from them over a month ago. And we kind of got right on it as soon as it came out. We submitted, had everything in order, had all our paperwork in order and everything. And, we had everything that they asked for the first time that we contacted. We didn't have to go back and forth with them. So I think that the message is that, whatever they ask for, make sure you have it when you contact them. And that may give you a better chance.
Thank you for that, David. That is good news. That doesn't help everybody, but that is good news. It's refreshing to hear that somebody, at least a landlord, has received payment for delinquent rent through the STAY program, because that's not the story for many of us on here today. All right, so I see your question, Marlene. You have a question. I'm going to get back to you. So there's a question in it. I realize that we are live on YouTube and some questions have come in from YouTube. So there's a question about South Carolina. Ms. Parker, I will check South Carolina information for you. Please email me, carissa@dchpa.org. I'll find out the resources that are available for landlords in South Carolina. Let me look at some other questions on YouTube. Candy has a question. What if you're a private owner? Can you refuse based on them having a low credit score? So Candy, that answer is no. In the District of Columbia, the laws have changed. I will send out the PowerPoint presentation that Mr. Billy Cannon shared with us today regarding the law and the application process, screening tenants, what you can and cannot do. So please email me, carissa@dchpa, and I will get you that information. Okay, so I'm looking at another question on YouTube. Bob Jones is asking, do these rental rights also apply to people who rent a parking spot? So right now, any lease, any contract, Mr. Jones, is unfortunately, everything is on hold based on the public health emergency. So if there's no specific language, then it's not covered. They don't address it specifically. We don't have an answer for it. So everything is on hold until the cessation of this public health emergency. So I know that might not be the news that you want to hear, but unfortunately, that's where we are right now. All right, and Silva Davis has a question. What qualifications must be met by the tenant to receive funds under the Stay DC program? So I shared information how both landlord and tenant must apply. And we just heard through David that they have at least dispersed or are beginning to disperse funds. So if you both have completed your part, you should have received an email saying that the application is completed and it's just a matter of waiting. But DC does have money available. I've applied as well for my tenants. So far, I haven't received anything. So we'll just continue to keep our fingers crossed. They're going to get it to us as quickly as possible. Cecilia, what programs are available? Please email me, Cecilia. Now, when you email me, let me know what jurisdiction, if it's in Maryland or if it's in South Carolina, specifically which areas, because I want to make sure that I'm getting you information for the resources that are available. Okay, so Marlene, I'm coming back to your question in the chat box. You're asking about rent increases for DC. As of now, no landlord in DC can increase the rent. So once the public health emergency is over, there's a timeline that you can increase the rent. So right now, it has been extended through July 25th. I don't know if it's going to be extended beyond that. So we just have to wait and see what city council is going to do. So unfortunately, we don't have the answer for that for you right now, Marlene.
Okay, can you hear me?
Yes.
Yeah. Okay, this has been a long-standing question of mine, is why Riggs Park, which has houses that's similar and superior to right across the street, Michigan Park, and also within close to Brooklyn, like at least at one time, almost $1,000 more for the same type of house or even smaller houses in those other neighborhoods. And I never got a satisfactory answer for that. And I've been losing money. I had my first and only housing choice voucher person since 2007.
Okay.
And I've spent like at least a couple thousand a year in order to pass inspections from damage that she has done. provided new appliances. They were brand new when she moved in there, and I replaced every one of them, refrigerator, stove, washer, and dryer. Okay. So it's just like if I can get her out, I can get, $3,000 plus a month, as opposed to the 1864 that I've been receiving a month through the DC.
So here is what I would recommend when we are out of the public health emergency and the DC. So because it is a voucher participant, so there are two things going on here that prohibit you from getting a rent increase. Number one, we're still in the public health emergency. But second,
yeah, I understand that.
Now, before we went into the public health emergency, the DC Housing Authority, they announced that due to budgets,
I know that too.
due to the budget, that nobody could get a rent increase. So, but here's the thing. Let's just say we are in the clear. We're out of the red. We're not in a public health emergency. DC doesn't have any budget issues. And they're saying, okay, well, Marlene, we are now allowing landlords to get a rent increase. However, Marlene, we're not going to give you any extra money because you're currently getting the max that you can for your neighborhood. Here's what I would do. I would have you to look at, or maybe speak to a real estate agent or somebody that can give you rent comps for your particular area. If you are able to provide rent comps to show that the rent that you're asking for is within means, or is within reason, or it is comparable to what's currently in that particular neighborhood, they will consider that.
Okay.
But you have to show the
check
proof.
Again, but I'm fully aware of the facts of the higher rent comps.
Okay.
And
yes.
I've posed that before, but I get nowhere.
Okay. So you, like I said, once we're in the clear, we're out of the red. You take your rent comps to DC Housing Authority. And if you're not getting a response, please contact the supervisor. I would strongly recommend that you maybe reach out to Ms. Janie Levy at DC Housing Authority at that time. I promise you that if you reach out to her now, you're not going to get any type.
Okay.
Yeah, you're not going to get any traction on that right now. So that would be my best recommendation for you.
Okay, thank you.
Okay, April, you have a comment about, are there template letters you recommend that landlords can use? So April, please email me. I can send you a link for letters. I create letters, but I also use a software program that helps generate letters. So it just depends on what type of letters that you're looking for. April, email me, carissa@dchpa.org, and I will get that information over to you. Let me go to my next question in the chat box, and then we're going to wrap up shortly. Does the landlord need to create a payment plan if the tenant receives assistance from the voucher program? So if you have a tenant that is delinquent in the voucher program, in rapid rehousing program, is a market tenant, it doesn't matter. The requirement is if they're delinquent on the rent, you have to extend the invitation to enter into a repayment agreement before you can take them to court. So if there's a loss of income, sometimes tenants don't report it to the DC Housing Authority right away. They may not report it to their specialist for whatever reason, I don't know. But if there's a change in their income and they can't afford to pay the rent, I, as the landlord, I will reach out to DC Housing Authority, maybe on behalf of my tenant, to say, hey, DC Housing Authority, one of my tenants, she had a decrease in her income. She's no longer working, or she's receiving unemployment. Who can she communicate with to have her rent redetermined? Because that's something that they do. Now, the state program, the DC state program, may be able to assist her with paying the portion that she's delinquent on. And if not, then you unfortunately will have to take her to court. But that's a good thing about having participants in the voucher program, because their rent can be reduced. Now, previously, here's what I do like about the state program. They also include assistance for voucher tenants. So previous funding wasn't available because it was just this expectation that because they are in a housing program or because their rent is subsidized, they should be paying their rent. Their rent is already affordable for them. So previously, some of them did not get assistance. So now through the DC State program, voucher section 8 voucher tenants, they can get assistance as well. So I do hope that that helps you. Are there any other last minute questions? And then we're going to wrap up. Please.
I have one, Carissa.
Okay, Barbara.
Do you have any, somebody asked earlier, Ron did, do you have any programs for property damage? I'd like to know the answer to that.
For property damage, I do not, but let me do some research to see if there's something available, if there's some resources available. Usually it's no, but I don't know. I'm not sure if there's funding available in the community for property damage. So that's something I'm definitely going to look into. Great question.
Carissa, one more last question before you go.
Okay.
So my tenant, if I give you the example of my tenant, so she moved in about 10 years ago. And so she had younger kids, you know, they were, at the time they were, you know, they were little 10, 11-year-old kids. And now they've grown, you know, the eldest one has master's, she's moved on. The middle one has also graduated and moved on. Now she's with only with one of the sons, right? And herself. So the voucher that she has is for a 3-bedroom.
Mm-hmm.
But last time she had difficulty certifying because I think she couldn't get all the documentation. Are they entitled for a 3-bedroom when she's just her and her son? And even her son is an adult now. And I feel like they're abusing it because, you know, this is 3-bedroom voucher, but it's just her and her son. Is that something that the HUD can help me with, DC HUD?
So when that happens, sometimes the families may not report to the agency that people have moved out of the home because they want to maintain a larger place, right? So maybe they had, in your situation, this family was larger, right? And so maybe somebody moved out, but this family possibly recognizes that if they report that somebody has moved out, their voucher size is going to go down. But now here's the thing. Once the voucher has been decreased to a smaller bedroom size, that means the agency will pay you less money. So let's just say, and I'm not asking you to tell me, I'm just throwing this out here. Let's just say they're giving you $3,000 a month, right? And that's for a 3-bedroom. And it's reported to the agency that the family size is only 2, which may take the voucher down to a 2-bedroom. So the agency can say, well, because we're downsizing the voucher, and of course they will wait until the family comes in to recertify. But they could take that payment down, let's say from $3,000 to $2,000. The amount will decrease when they lower the bedroom size on the voucher.
So the landlord will be the one losing out, not the tenant.
Absolutely. Absolutely. So if the agency is still paying the money, they haven't stopped the money, then if it's not broken, just let it.
Yeah.
So you got to weigh it. So don't concern yourself with whether or not this tenant or the family is violating their family obligations, because that's the agency's job to find out, okay, do you still need housing assistance? They are required to recertify. They're required to recertify, and that's a requirement because DC Housing Authority, let me just say this, I see you, Anna. DC Housing Authority is not HUD, but they are federally funded by HUD. So that means that HUD gives them money. These tenants are required to be in compliance. They're required to either every year or every 2 years recertify to determine if they are still eligible to continue to receive housing assistance. Yeah.
Right. But I feel like they're I mean, this is fraud, because if I am stating to the district that I have, you know, I have a need for a 3-bedroom because my family size is larger, but in reality that's not the case. That's fraud. My thinking was, when I report that, they want them to find a 2-bedroom, you know, or 1-bedroom or a 2-bedroom, and to leave this property, but that's not the case, right?
That's not the case.
Right.
That's not the case.
Yeah,
So now it could be fraud, and maybe let's just say maybe whoever moved out, let's just say they're in school or they're away, but they're coming back. They're allowed to do that.
No, thank you.
Yeah. Okay, Anna, did you want to say something? Okay, so what I am going to do is I am going to I'm going to follow up with all of your questions in the chat box. I am going to ask that everybody that had specific requests for me, please email me so that I can follow up. I'm going to have Billy to look over all of these questions, and we're going to resume next month. Billy is going to come back next month, so please come with your questions. It costs you nothing to get this information. I do hope that this was helpful for you. Thank you so much for tuning in. Thank you so much for joining us for the discussion today. This session is being recorded, so if you received an email from me, you will receive a link to watch the replay. Okay. Was this helpful for everybody? Was it any other questions that we did not address?
This was absolutely fantastic. If you could share his details so I can call him, so he can take up my case, that would be wonderful. Other than that, we really appreciate your efforts. I really do.
Yes, thank you
Carissa.
so much, Carissa. This was a
Wonderful.
very good
Thank
session.
you.
Thank you.
This was extremely helpful. Thank you for all you do, honestly.
It's my pleasure. Thank
Extremely
you.
helpful. I'm so thankful for you.
My pleasure. Now, I just
Thank
want to
you.
say for
Bye-bye.
Thank you.
goodbye.
Thank you, Carissa. This was amazing. Absolutely
Yeah, I
amazing.
agree.
Always
Seriously.
so dead on.
Yeah.
Right.
I really appreciate you. This information is something that makes all the difference for us landlords.
Likewise. Yes.
So please don't stop doing what you do. We deeply appreciate you.
Thank you. Thank you so much.
You're welcome.
So
Good night, everybody.
Good night. So for
Good night.
all of my students, please make sure that you jump onto WebEx. All of my property management students, you know who you are. Please make sure you jump on for the follow-up.
Carissa, quick question before you leave. I know you mentioned property managing students.
Yes.
What exactly, do you teach a class or something?
Yes,
Or-
that is a great question. Yes, Amanda, I teach college property management for students looking to get into the property management industry. And I also do landlord coaching where I show landlords and owners
awesome.
how to create rental property businesses, how to set up systems to effectively manage your tenants. Yes.
Now, what college are you at? Because I would love to I'm in the healthcare field, and I'm, of course, a landlord, but I would love to do this.
Okay, great. So Amanda, do this for me. If you will
Yes.
email me, I will send you the link where you can register. So we are
Awesome.
we are now accepting registrations for the fall semester.
Oh, fantastic. I would love it.
So if you will email me, I will send you that link so you can register for the fall class.
Yes, I'll definitely do that, Carissa. Thank you.
Again, it's my pleasure. You're welcome.
So,
So
Carissa, it's Sandy. Count me in. I'll be sending my information as well for the class. Thank you.
all right.
Thank you.
Good night, everybody.
Good
Good
night.
night, Carissa.